Hello and welcome to this episode of Scrutiny. And this is my weekly, deep research based insight into issues of significance or issues that are in the news. And as always, we try and bring you clarity from clutter and ensure that at the end of hearing this, you know a little more about issues and its impact than what you did earlier. The farmers of Loutolim and the protectors of its Khazan lands have finally received a court order that gives them some protection, even if it's a temporary protection, against the takeover of their farmlands and Khazan lands for the proposed Bori Bridge, the new Bori Bridge in South Goa, which is currently being built to facilitate the transport of coal-laden vehicles from the Murmugao Port Trust to other states, with Goa being used to be just polluted and its pristine Khazan lands destroyed. This is Inc. Goa, and we say it straight when it comes to issues of Goa and Goans. I'm Shujoy Gupta. On the 30th of July, this Thursday, the High Court of Bombay at Goa has granted an interim stay on the implementation of the declaration through which land was acquired for the bridge. It simply means that the process of completing the land acquisition for the bridge has been stayed, albeit temporarily. The government has also been restrained from cutting trees or beginning construction on the acquired land without the permission of the court. This is a victory of sorts because very rarely do we see in Indian litigation history against highway projects that these kind of stays have come in. Yes, there are more and more stays that we have seen, especially with regard to stopping cutting of trees. But the stay against the acquisition, land acquisition itself, is something that is not very common. So in that sense, this is a very significant order. Now the order has stated, and this is important, this is what the order has stated. Now it has said that there are three sections, section A, B and C of the National Highways Act, which is nothing but which outlines the process by which land acquisition takes place. It talks of issuance of notice, objections and so on and so forth. So A, B and C, there has been no change. In any case, A, B and C stages have passed. The stage 3D declaration is a declaration by which the land acquisition process is carried out, it's implemented. After all other clauses are taken care of, this is that final act under which the land acquisition actually takes place. And this is what the farmers of Lodoli were waiting for with bated breath. They went to court, they've been fighting against all odds to see these beautiful pristine lands, which you will see shortly, being taken over. So the 3D declaration made on October 11th, 2024 has been stayed until the writ petition filed by the Tenant Association of Loutolim is finally decided. The authorities cannot take possession of the land under section 3E, which means after 3D, when the land acquisition process is completed, the possession happens under section 3E, that is also stayed. It cannot dispossess the petitions, very important. It cannot create any contractual or third party rights based on the section 3D declaration, which means they cannot take over and start working on that particular land by literally throwing the people who are there, the farmers, out. Now, also, there is something called the compensation. Importantly, the court has said the compensation under section 3G and all steps taken after the 3D declaration will remain subject to the final outcome of the petition. But here's the catch. The government is still free to obtain CRZ, forest and other statutory clearances. It is still free to conduct quote-unquote lawful and non-invasive surveys. It is still free to prepare plans, estimates and other documents, including it is free to invite and process tenders. What is therefore seems surprising to people is, on one hand, the land acquisition process has been stopped, but all of these processes that ultimately should take place only after the land is acquired, these processes have been allowed, and so that is why this is important to be flagged. However, no work order or on-site construction can be acted upon without the High Court's permission. It is not said it cannot be acted upon, but it cannot be acted upon without the High Court's permission. Of course, they have also said that government may apply to the High Court again once everything is cleared to modify or vacate this interim order and seek a final hearing. So that's a legal option that is still available to the government. So now let us go straight on the ground, as we always do, to the Khazan lands of Loutolim and talk to the farmers, the chairman, the president, and the secretary of the Tenants Association, and let us see what they have to say.
Totally, you said one word, Supreme Court. I took one step at the back because we are tired of the courts. We are farmers. We are in NGT, we are in High Court. Will we do farming or will file court cases? Anyway, now that we are already there, it's a temporary relief. But there's a lot of reason behind it. Now, the government is of the opinion they will take possession of the land
Right.
and obtain permissions, whatever, from forest or CRZ
Right.
later.
Right.
Now, what is the hurry? They have issued notices for award the other day. Of course, they were not served, only one got served. And mandate form also was there in that. Suppose if government had to disperse the awards, funds would have gone into their account. Then the recovery proceeding will start if this is dropped. So what is the hurry? There is no hurry in this. The land is there, Kazan land is there. And why do you want to, see, we have told them in 101 ways that this is Kazan land and we are not going to get another Kazan again. This is not ordinary land. People are surviving on it. If they got only basic one reason saying that it is a shortcut and there are no houses going, in Kazan you don't expect houses to be there. Other 1,000 houses would have been there. So have some sense, no? What relief we have got is a big relief. At least we know that they cannot take possession of our fields. And forget taking possession of the field. The notifications that are attached, EIA, forest, CRZ and all, it is not easy. These are the notifications by the government itself.
Correct.
And how will you comply with that?
Correct.
It's not possible.
What are going to be your next steps? Your next steps.
Next step should be coming from them. See, now we are at the standstill.
Right.
Okay.
Right.
Now they are at back foot. So they will come and put up certain things, and we will defend.
Right. Right.
We will defend.
See, when the people came from department
Right.
to survey this land,
Right.
our latest Diana,
Yes.
who is there, was there.
Yes.
She themselves asked them, before doing this, why you have not made that other procedure including that?
Including CRZ.
Yeah.
Yes.
So they have no answer at all. They say that we will do after. Then she told, let it be first, then you go forward. They
Right.
have no answer at all.
Right.
Because of that only it was stopped.
Right. And what is the alternate solution if a new bridge happen without disturbing the Khazans?
It was possible. Initial stages, it seems the bridge was to be coming up somewhere far away where it was not crossing the Kazan. From the hill, it was crossing the Zuaris and going the other side. So I don't know what is there on the other side. There are problems or not.
Right.
Pit stop. And this road by missing link came. We were very happy to give missing link. Even my fields are gone. Because the whole traffic was moving to the village.
That's right.
Like ants.
Correct.
So we are happy that, okay, missing link is made. Okay, enough is enough. But because of the missing link, someone calls that my baby. Now the baby is grown big.
Right.
Whom to get married to?
Right. Right.
Huh? You tell me, should we be responsible for it?
So these were the words of the Karbot Kantar Makazan Tenant Association of Loutolim. They are the foot soldiers who are fighting to protect their land. And while they are satisfied, they very well understand that this fight is going to be a long fight. And one word uh, of Albert Pinero stood out, that we are ultimately farmers. How long can we fight cases? We have to be on our farms. However, it is important again that this is not a final cancellation of the project. It's not yet a final judgment. The fight is still going to be long. The government may even seek a CRZ clearance, which is important. So let us now look a little bit, go back and look at what the case is all about. Why are the farmers fighting for the new bridge not to be built in the manner that it has been planned? So the petitioners are all farmers, agricultural tenants, residents, and landholders from Loutolim and Borim and the adjoining affected areas. They have challenged these acquisitions and notifications that have been issued for this new Borim bridge and its approaches, and the proposed bypass proposed bypass to National Highway 566. Now the big question that we are asking today is, can the government acquire hundreds of thousands of square meters of agricultural Khazan land, forest and residential land, when the necessity of the project, its final design, environmental consequences, and even the alignment itself remains contested? This is what we are asking. This is pristine land. This is Khazan land, protected and owned by the comunidades, farmed by our farmers. How can you take this away? And that is the subject of today's scrutiny. So the government, as we all know, first issued a notice under Section 3A to acquire the land. Then they went through the whole objection process, and 197 objections were filed by the affected villagers in November 2023. Now these objections, as almost always, were rejected, and during March 2024. And then the government thereafter issued a declaration under Section 3D, the final declaration of acquisition, on October 11, 2024. But you must understand that this actually means a 3D declaration is not an ordinary document. It means that after your 3D declaration, the land actually vests with the central government, free from encumbrances. So look at the fight that these villagers are fighting. They are not fighting against the state government. They're actually fighting against the center. And you have seen them. You just heard what they had to say. You see, these simple farmers have taken on the might of the central government here. Now, on July 15th, the state assured the court that it would not argue that the petitioners had lost the right to challenge the acquisition. So at least that much the state government gave. And that is important. Now let us look at the old Borim bridge and the new Borim bridge. And the justification given by the government that the old Borim bridge is totally, going to be non-functional, and therefore we need the new bridge. Now the government has on one side argued that the existing Borim bridge is old, distressed, only 2 lanes wide, and insufficient for present and future traffic. And that is why it has justified the new Borim bridge with a 4-lane approach and so on and so forth. On the other hand, the government is also saying that the existing bridge was approved for strengthening and rehabilitation at a cost of 20 crores. So you are also rehabilitating the old bridge, which you are now saying it's stressed. The proposal placed the cost at about 22.95 crores. That was the escalated cost. And then it said that the bridge would get a life of more than 20 years. So where is your basic argument that the bridge is stressed? And that is what we must understand. Then we must also look into the traffic data, and I'll get into it in a little bit. Whether a new bridge is needed or an old bridge needs to be either repaired and both the bridges continue parallelly can be deduced only if you have a detailed project report and a cost-benefit analysis, a DPR and a cost-benefit analysis. Now, the petitioners are arguing that the planning for the new bridge effectively treated the existing bridge as if it would no longer be available. But the facts on the ground show that the government on its own is attempting to revive the old bridge at 22 crores plus. This is the confusion that is ultimately there. There is no clarity. Also, there is absolutely no data to show what the traffic is going to be if the current bridge is repaired. And that is what we are trying to say. In other words, the government is spending more than 20 crores and is going to be even more than that to extend the life of an existing bridge. While the new bridge is being justified by saying that the old bridge is too old and it will no longer exist. Look at the contradiction. And this is where we need to figure out and nail the government on these contradictions alone. That what really is the purpose for this new bridge? Is it just to ensure or just to handle additional traffic? Or is it just to merely transport coal? Now, also what is interesting here, look at the traffic study. What is the government saying? The government is saying that more and more cars, vehicles are going to come into this area and the new old bridge is not sufficient enough. Now, let's look at some data. Now, the consultant that prepared this traffic survey in the year 2016. And that is the time it recorded 29,794 vehicles per day, representing about 33,990 car units, passenger car units. And it included a large number of trucks and heavy vehicles. But then, do understand 2016 was not a normal traffic year. Do you remember that the old Zuari bridge on the Kortali-Agasai route that time was heavily restricted at that point of time because the old Zuari bridge condition was bad and all heavy vehicles were plying through this Borim route, which is why the volume of traffic recorded in 2016 was abnormal and much higher than what the normal traffic is. When the Zuari bridge opened, the new Zuari bridge opened to traffic in 2022, the traffic through this Borim route fell substantially. And then when the fresh tabulation was done, it fell from 33,990 car units per day to 12,010 car units per day. So your justification in having a new bridge because of heavy traffic gets defeated by this data alone. It is 65% lower than the figure quoted by the highly paid consultant in 2016. And this is why we need to understand these things on how even traffic data is not absolutely clear and there is more to it than meets the eye. We will now look at one more aspect. Was there a final detailed project report before the land was acquired? This is a very troubling aspect. What is the status of your DPR? The consultant submitted an inception report in January 2017. The report contained a schedule under which the final DPR and the associated environmental studies would be completed. But the petition says, the same petition that we are discussing today, that no final DPR was prepared or submitted even after the acquisition proceedings began. You are acquiring land, taking away land from the farmers without even completing a DPR. Subsequent correspondence contained in the petition appears to show that the design continued to change even after the Section 3D declaration, which means even after you have acquired the land, given notices, you are still continuing to change the design of the bridge. How is that possible? Because when you change the design of the bridge, then the land that you need and the survey numbers that you need may change because your design itself is changing. The consultant was still being asked to modify the general arrangement drawing, the GAD, enumerate trees and structures, and prepare proposals for additional land near the Dhavli junction and the Baithak Khol junction and the Missing Link junction. All this is happening post facto, after you've decided to acquire the land. Now, this is important. Without the government saying why the project is required, what traffic it must carry, what alignment it best serves the traffic, what engineering structures are required, how much land is genuinely necessary, what environment and social damage it will occur, whether an alternative can achieve the same purpose with less destruction, you go ahead and decide to acquire the land. And these are pristine Khazan lands. If this is not an absolute travesty, then what is? Now, the project itself changed. This is important. Between Section A and Section D, meaning between the time when the government decided to acquire and from the time and to the time that the government actually acquired. The Section 3A notification proposed the acquisition of approximately 3,93,184 square meters or 39.3184 hectares. The final 3D declaration covered approximately 3,40,253 square meters or 34.0253 hectares, which means more than 52,000 square meters disappeared between the intention to acquire and the final declaration. Fair enough. If you are acquiring less land, it is better. But there is no transparency ever on which land was removed and how it was removed. And also, the portion of the deleted land included an arm that was required to serve the Ponda to Margao route, which actually caters to large scale existing traffic. So the land that is missing when it comes to 3D, the less land that is shown to be acquired, it also includes the Ponda Margao highway route, and the maximum traffic is going on that route. So this is what is important, that ultimately we do not know why these changes are happening, whether you are acquiring less land or more land. Did the traffic model change? Was the cost benefit analysis different? These are important questions that we need to ask. And now we come to the most sentimental aspect of this project, the Khazan question. The strongest environmental and livelihood concerns the Khazan lands of Loutolim and Borim. Do understand, people who are outside Goa, this is a very unique system. These are pristine lands protected by village communities so that they are never taken away and used for farming and agricultural purposes only. To protect Goa, to ensure that it has enough food. Do understand the meaning of these Khazan land. Do the people who do these arbitrary plannings, do the people sitting in MPT, do the people who want to push coal even know what these village systems mean? Do they know what community farming is? They have absolutely no clue. Khazans are not ordinary paddy fields. They are highly engineered agro-pisciculture systems created over generations through bunds, through sluice gates, through channels. All this is important. This is controlled interaction between saline water and fresh water. Do they understand that? Does the Honorable Mr. Nitin Gadkari, the Minister for Highways, understand this? Does the MPT chairman understand this? Do the big conglomerates who are going to be pushing this coal, do they understand this? This is what we need to know. Now, the petitioner says that this project does not merely acquire individual strips of agricultural land. They argue that an elevated road, embankment, approach road, all of this can obstruct the movement of water and destroy the viability of the fields beyond the acquired strip. Do understand this. When the relation between saline water and fresh water completely gets destroyed, you are not only affecting the strip taken over, but all the surrounding areas. 1,57,000 square meters, almost 40% of the original proposed acquisition consists of Khazan land. I'll repeat this again. From the entire land that you are acquiring, 40% belongs to Khazans, 40% are Khazan lands. Is anybody aware of these figures? Also, the petitioners have also argued that the Lotoli and the Bori Khazan lands fall within the CRZ protection. And this is important because the government response claimed that only one survey number in Lotoli involved Khazan lands and that it represented only 1.41% of the acquisition. It gave a reason that viaducts would be used to minimize the interference with the water movement, paddy and the pisciculture. But this is not a small difference in interpretation. One side says that 40%, and we believe that side because that side knows its fields. The other side says the Khazans is only 1.41%. And do understand why I'm spending time on this. Because the battle for the villagers will be won or lost on this fact alone. Whether they manage to convince the courts of this genuine fact that they have of the amount of Khazan lands that are going to be destroyed. And this is going to be key to winning or losing this case. And that is important. Also, court has allowed the government to apply for a CRZ, Coastal Regulation Zone clearance, correct? In this very order that we are talking of. But the government must place, and the court, and one should appeal to the court, and the government must place a survey-wise overlay of these facts: the alignment, the proposed coastal zone management plan, CRZ categories, Khazan boundaries, bunds and sluice gates, tidal channels, bridge piers, embankments, ramps, construction yards, and areas that will be acquired during construction. It is very important to note what are you taking over with absolute data and honestly. And only then can a CRZ clearance be done. It cannot be done in an ad hoc manner. Also, I address one more question. Can the CRZ be obtained now in a post facto manner? After a stay has been given on the acquisition of land, the court, the Honorable Court, and that is in its wisdom has said this, and that has to be followed. But with absolute respect to the court and in deference to what the lordships have said, the question that one can genuinely ask journalistically is, can the government obtain a CRZ clearance? Because the petitioners have have ultimately based their petition, relied on the Supreme Court's decision in the Project Director Project Implementation Unit versus PV Krishnamurthy case. If you want to deep dive, go into this case. Their interpretation is that a declaration under Section 3D should be made only after the required environmental and forest clearance concerning the specific land that has been granted. This is a Supreme Court order. Today's order is a High Court order. I am pointing to a Supreme Court order, which very clearly says that Section 3D should be made, which means land should be acquired only after the required environmental and forest clearance concerning the specific land has been granted. I am only gently pointing to the Supreme Court case, Project Director Project Implementation versus PV Krishnamurthy. So basically, the argument is therefore not simply without construction can begin without clearance. The argument is that the Section 3D of land acquisition itself was premature because it was issued before the environmental and forest permissions. The government may respond that different clearances operate at different stages, and a preliminary land notification does not require all the final permissions, and no construction will take place unless all the approvals are granted. That can be the government view, and that is something that the High Court must determine. But then we have a Supreme Court order which has already determined these things, and it has to be seen in that light, and we will see how this goes. Then, of course, let us look at the forest land and the tree felling issue with regard to this case. Now, importantly, survey number 28 of Kilo C was provisionally identified by the Thomas Committee as a private forest. Do you remember the Thomas and Araujo Committee which identified forest project? This was survey number 28 in this area in Kilo C, adjoining Kilo C, was identified as a private forest. Now, additional survey numbers in Kilo C and Bori contain dense forest and form a connecting corridor between government and identified private forests. During the land acquisition hearings, the project authorities maintained that no forest land was affected and that environment clearance was not applicable because the road length and right of way fell below the relevant thresholds. But then fresh material emerged. A May 2026 RTI from the Deputy RTI reply from the Deputy Conservator of Forests has confirmed that forest conservation provisions apply to survey number 28 of Kilo C. The same report stated that no permission had been granted for tree felling. The environmental documents automatically contemplated the removal of approximately 4,875 trees, and petitioner said the actual number may be higher, but this RTI reply very categorically confirms that forest conservation provisions apply to the survey number and tree cutting cannot be done. Which is why the High Court restraint on tree felling is not incidental. We are very glad that the High Court has come down in this very order that is under discussion on tree felling. And it has restrained the tree felling. Also, because it is important, because once there is a mature forest, how can you again cut that mature forest? So this restriction is therefore very important. Now let me go to another section. I know this is a long vlog. Be patient with this because the future of Goa and the future of farmers is at stake, and it's very important to delve deep, and that is what scrutiny is all about. So bear with me, please. Now, let us look at panchayats and gram sabhas. Are panchayats and gram sabhas mere spectators? Because they were not consulted before critical decisions were taken. The Lotoli Gram Sabha passed a resolution opposing the acquisition and requested that the notification be cancelled. It called for a public hearing. It called for a disclosure of public information and the project information. The Lotoli Panchayat asked the PWD officials to attend a Gram Sabha and explain the project. This is in the petition. But officials came only after the acquisition notification had been issued. What is the point of coming then? Bori residents similarly complained that they were not given a meaningful opportunity to oppose the project and engage with the project authorities. And that is what is important. When do you consult? What time do you consult? Do you consult after the ship has sailed, after the land is acquired? And then let us now discuss one more issue. Is the project really for port and coal connectivity? Now, obviously, the petitioners have said this alignment was chosen only to serve the MPT's coal transportation and nothing else. Records also state that National Highway 566 is a port connectivity route. A 2017 communication selecting alternative number 7 referred to the shorter distance of traffic leading to Mormugao port and the priority attached to this particular port movement. The petitioners have also connected this to a master Sagarmala plan project and the expansion of port capacity. They argue that the arm serving the Ponda-Margao traffic was removed because the project's principal utility increased substantially and became the movement of traffic towards Verna, Vasco and the port. So this became more important than the Ponda-Margao, which this change of alignment indicates that it was not to control traffic on the Ponda-Margao route, but for this port connectivity along this port route. And this is important. Also, What proportion of the projected traffic and economic benefit is associated with port freight? And was that informed honestly before this alignment was done? That is important. So all this is important. That what is the benefit that you're giving to port? What is the benefit that you're giving to port freight? What is the economic benefit that you're giving to the MPT, its business, and for people who are transporting coal at the cost of our simple, humble farmers working on Khazan lands, producing food for Goans, and keeping our agricultural spirit alive. Now, what does this order ultimately mean? It means that the petition raises questions serious enough to justify judicial protection, and that is important. The government cannot proceed recklessly. The government may pursue with the CRZ clearance, but the High Court still retains control over whether and how the project may advance. However, I humbly argue with absolute deference to the court that the CRZ clearance application, when the 3D application itself is under challenge, should not be done. In all humility, that cannot be permitted. However, ultimately the court is supreme. In conclusion, what should the government finally do? Put out a final credible DPR. Give us the final alignment and drawings. Us meaning the petitioners and the people of Goa. Give us the complete traffic model. Give us the 2026 and updated traffic surveys. Give us the structural assessment and the future role of the bridge, of the existing old bridge. Give us the survey number wise CRZ and Khazan mapping. Important. Give us the forest identification reports. Give us the total tree enumeration reports. Give us the hydrological and flood studies. Give us the social impact assessment. Give us the rehabilitation plan. And give us the total financial burden on Goa and the center, that cost of the project is going up and up and up. And we need to know. All this is important. It is not, the Borim Bridge is not a fight between development and people who are opposed to development. It's a test of whether Goa, while pursuing the development route, will follow evidence, will follow law, follow democratic consultation, and protect the common man and the common farmer. And that is important. Because with these extraordinary contradictions, with these extraordinary overreach, and with the extraordinary assumption that everything goes and poor farmers on Khazan lands will not challenge you, this particular judgment should absolutely quash those high-handedness and those kind of assumptions. If young children can demonstrate in front of Jantar Mantar and cause the education minister to resign, do understand that Goa's farmers have the strength to fight against a grave injustice against their Khazan lands. And this is very important. Goan farmers will not keep silent. They have knocked the doors of the court and they will fight this fight legally. So this is not obstructing development. It's a minimum discipline that Goa requires and the center requires, Mr. Nitin Gadkari requires, dear minister, before you sacrifice another village landscape to a project whose design, purpose, environmental legality remains under serious challenge. Thank you. Keep watching In Goa. Do follow us, do subscribe, and do support us.